I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are courtroom hopping back into the courtroom of Judge Victoria Shackleford for the third appearance of a pretty popular sovereign citizen that many of you may know that keep up with the sovereign citizen movement, and some of you may not. Being that this is his third appearance, it's actually his second appearance before Judge Shackleford, and he also has an appearance, which was his first appearance before Magistrate Delphia Burton. What I am going to do is I'm going to put all three appearances together, so that way, those of you that don't understand what's going on, if you were to jump into this third appearance, you can see from the beginning how we got to where we are now. If you're familiar with the case, you've been following along, there will be chapters added for you to just jump straight to this third one. But with that being said, this will be three appearances. Once again, one before Magistrate Burton, two before Judge Shackleford, with chapters added. And with that being said, guys, let's go ahead and jump into these proceedings.
Chamberlain, just stand right in front of that one.
Oh, look like HP is in the waiting room too. So we'll bring him in. All right, good morning, sir. Give me one moment.
Good morning.
Highland Park. Oh, is that Officer Monroe? Hello, Highland Park. Okay, we're gonna wait. Your name, sir, for the record.
I'm up your Roman Susticate Trust legal fiction corporate entity defendant. That's what you want. I am one of
Okay,
the
well, this
sovereign people.
yes. Okay, all right, so this is for Eric Joseph Martin. And Officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay,
I object to that any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people living on the land, not the corporate entity defendant.
Okay, sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the battle. Move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Define probable cause as fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin.
Hold on,
Mr. Martin.
It's kidnapping.
No. What we're going to do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing, and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm going to entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just gonna set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because see, the officer filled out the complaint form. He's lying
Yes.
by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of my due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My
Mr.
sister
Martin.
has been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her. So she really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clifford in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process right. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that. So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave this state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. You're going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done.
What is her name? Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Thank you, Your Honor. I appreciate it.
Next we have Mr. Martin. Mr. Martin, sir, are you ready to be arraigned? Can you come up here, please?
This is Mr. Martin. All right, this is 251756, the People versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at 9074 Clifford in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned. Yeah, he's just. Oh, so you know the original charges against you. And part of those charges against you, let's see. You could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address at 9074 Clifford. And you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations. It looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, officers were dispatched to that location. And there are allegations that you entered the residence through the back door, and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
Well, I move to dismiss the charges because the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity defendant, which does not mean I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm going to say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
Oh, okay. Well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
Well, like I said, I moved to like I said, the bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition violation is legit anyways. And there's no probable cause in this case. I should have been arrested illegally anyways because there is no evidence. My sister lied. Her allegations are a total lie.
All right, you have a right to remain silent. Anything you say orally or in writing can and will be used against you, sir. You understand what the allegation is? You were just arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr. Martin, this is I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I don't have a choice. I have another house to go to for one. Besides, it's violating my
Well,
rights.
now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
Yeah, well, guess what?
jail.
You
We'll
guys
see you
are
at your next
violating my
court date. All right, thank you, officer. We'll see you next time, Mr. Martin.
Okay, goodbye, Mr. Martin. Okay, goodbye. Have a seat, Eric.
Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her. Did you swing at me before I kicked you? She answered no to that, and it was seen on the camera. She lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial by
jury, so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. Okay. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced the sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution. which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find
Despite
me
the fraudulent presumption otherwise.
possible? All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even do on a state date.
I want to make clear, point out, it's supposed to be 28 days and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific under the court rules, it should be 28 days without excluding Saturdays and Sundays or the legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, you know, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, we would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about, there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before. And there is no evidence at all. We have no case. There's no evidence. And that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, it's a misdemeanor, so we're not having a preliminary exam. We're having a bench trial. And the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this, if she can, you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
You haven't let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against, we simply have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be, let me finish.
Okay, denied. All right,
the case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay. Thank you, Mr. Gazicki. That's it, right?
Well, guys, we've come to the end of all three of these proceedings. I am not going to do commentary on the first two because I've done that already. But on this last appearance for Mr. Eric Martin, honestly, it's not even a whole lot of commentary to even do on it. I mean, from what I see, Eric Martin, Mr. Martin, man, he just want to be able to say all that he has to say. And if he can do that, he seems to be pretty satisfied. That's whether you're listening, whether you're not, whether you're sitting there or whether you're not. He just wants to get whatever it is he wants to say on the record. We see that he's going for the bench trial before Judge Shackleford. And I think that's going to be a good thing for him because, for one, I think she can be objective. I think she's going to be fair. And she's already told him, listen, if the prosecutor does not prove the case without a shadow of a doubt, best believe you will be, exonerated of these charges. The case will absolutely be dismissed. Her being a lawyer, she knows what to look for. She knows when a case isn't being presented, obviously being a judge, the correct way. So I think he's in good hands as long as he didn't do what they're saying that he did. But I mean, when it's all said and done, who really knows? But we're going to continue to follow this case. Judge Shackleford denied his bond because, unfortunately, because of his beliefs in how he thinks, he can't be trusted out on bond again after going to his sister's house, or maybe it is his house and her house together. I mean, I don't know, but his bond condition says don't go over there. He went anyway. He doesn't believe they have jurisdiction. He doesn't believe any of whatever the court has, pertains to him. So I get why she did what she did. So we'll see what happens on July 14th. We will continue to follow this case. With that being said, guys, I appreciate you. Thank you. Like, share, subscribe, whatever it is you need to do to help the channel keep growing. I appreciate it. With that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. Talk to you guys soon. God bless.